Yeah, should I begin? Yeah, all right. Good evening, everyone. Welcome to the 12th session, study circle session of VP Shintre and Associates. So, our today's topic is on startups, legal and tax perspective. So, just to give a brief history regarding study circle session. So, this was started by Advocate VP Shintre and Advocate Bendre in 1985, and these sessions would be conducted in men's bar the district court premises. So thereafter, carrying the baton forward, these study circle sessions were conducted by Advocate Vaishali Bhagwat and Advocate Pramod Bendre. So now in this digital age, we have decided to continue this tradition of the study circle through a digital medium. So I would kindly request everyone to switch off their video and turn off their audio. Yeah. So our today's guest speakers are Advocate Sidartha Jathar and Advocate Kunal Gokhale. So Advocate Sidartha Jathar is an alumnus of ILS Law College, Pune. He worked with PepsiCo Legal as a trainee right out of college and has over a decade of experience. Thereafter, working with entrepreneurs and fundraising, initially as a participant and co-team member of a non-governmental organization, which is called Jagriti Yatra, which focuses on entrepreneurship and development in India. He worked as a lawyer in Mumbai and Delhi as well. Now he works with the corporate practice group of Kocher and Company, and he specializes in investment deal documentation for venture capital investor and startups. Our second speaker for today is Advocate Kunal Gokhale. Advocate Kunal Gokhale is an advocate practicing at Pune. He's an alumnus of National Law University, Jodhpur. He specializes in income tax and corporate commercial matters and has around 11 years of experience. He is engaged in litigation as well as advisory work. He was working with firms like Luthra and Luthra Partners, Ernst and Young LLP, Wesh Associate Advocates in the past. So he has also judged various moot court competitions and given various lectures. So we welcome you, sir. So the reason for conducting today's study circle session, which is on startup, is because in today's environment, the startups are very crucial as they focus on innovation, and also they lead to employment generation, and also they promote research and development. So the legal compliance and its importance is often overlooked by many startups, which are new to the business ecosystem, simply because they are not aware of their legal rights or existing laws. So the founders of startups give more emphasis on the product, but less emphasis on the legal compliance. It can affect startup viability and attractiveness of the potential investor as well. So why this is important? Because such diligence and foresight would benefit both the company as well as the investors, simply by assuring that potential investors that the startups they are investing, which should be in the safe hands, and they should gain the trust of the investors, right? Yes, so it is always safer option to get your business registered in the initial stages and pay the taxes rather than getting caught and paying the penalties later, and then you can maybe get into trouble in a lawsuit. So it would be helpful for the startup founders to be aware about their applicable laws as well beneficial legal provisions for them, like MSME or Startup India. So I would like to ask a couple of questions to Advocate Sidartha Jathar. Sir, what has been your experience like as a lawyer with working with startups, or how did you get involved with servicing the startups? And
Thank you.
also, yeah, and also what stage is the early stage when businesses usually should get touch with the lawyer, the new startups which are coming in right now? So when they should get touch with a lawyer or a CS or a CA, sir?
Thanks, Shruti, for your question. I think your first question was what my experience has been like working with startups. I mean, I have to say it has been absolutely wonderful. I find startups to be very inquisitive, and entrepreneurs are usually keen to understand details of legal compliance and documentation, how it will impact their business. They are very hands-on, and initially they do require a bit of engagement. Um, Maybe sometimes it's a challenge to convince them on reasonable timelines, but I've seen early stage founders mature into more seasoned entrepreneurs who then value documentation and compliance. Personally, I got involved in this entrepreneurship development space because I was working initially right out of college with a non-profit that focuses in entrepreneurship development called Jagriti Yatra, as you had correctly said. So I had experience with programming and fundraising for that event and program. So it was a very organic transfer finally for me of skills and interests and passion from that to servicing startups as a lawyer. Now I've done that for more than 6-7 years. So it's become part and parcel of who I am and what I do. I certainly feel that on your other question of when they should engage with lawyers or CAs or CSs from the very beginning. And the reason is that there's a lot that can be done correctly at the beginning. It's relatively easier to set up processes and systems when you're small. And then as you grow, it becomes less difficult to maintain those standards. So certainly at the beginning, also because you can make better choices at the start, keeping in mind what your future plans are. So the earlier documents are in place, the better, in my opinion, humble opinion. And it's not unusual to see startups use legal services from the very beginning. If I were to just give you an example as to when or why somebody would come to you and how they might benefit, it is when individuals are, say, they get out of a job and they're starting a startup. A couple of young founders, one of the things on their mind would be, how they should have an economic and power arrangement between and amongst them. So at the very beginning, when they are drafting their articles of association, they would benefit from advice on how to protect their individual interests, because those interests are relevant, without taking away, of course, from the collective interest, collective goals of the organization that they are starting. So that would be one reason why somebody would come to you very early. Another reason would be, let's take an example. Somebody who's just doing yoga, is a yoga practitioner, right? Somebody who is running a sole proprietorship, which means they don't have any registered entity. And in fact, let's say they come to you and they ask you for advice on how to incorporate, how to limit their liability. What comes to mind is, let me incorporate a private limited, right? Because that's what many people know, or an LLP. But in this case, let's say the entrepreneur is very clear that he is going to, or she is going to bootstrap. You're going to scale up, but not massively, right? Continue to undertake yoga related training and activities, and maybe even start a center, use money to fund a project, but essentially keep control and investments all within the realm of just himself. So it would be worth considering whether such an individual should go in for a private limited company or not. He or she may benefit from a one-person company, right, where you have one director, one shareholder, and the number of compliances are far fewer. So the point being that you must think about customizing the entity that you would incorporate to what your needs are. I think that is where you would benefit from early advice. Maybe this is this distinction between how you should incorporate a company, whether as an OPC or as a private limited or an LLP, is something we can talk a little bit more about, and I believe Kunal will speak a bit on this topic.
So thank you, Siddharth. So, yeah, I'll just quickly discuss, what are the forms of the entity to conduct the business that a startup founder can consider. So, based on my reading, basically there are three important points which a startup founder should, keep in mind or decide upon as to what his objective is before he chooses which entity should be taken to run his startup business. So these 3 points are the flexibility with respect to conducting the business. So just to give a small example, if it's a partnership firm through which you're conducting your startup business, then there will be far greater flexibility to run your business as compared to probably a LLP or a company. So just to give an example, in case of a partnership firm, now statutorily, the partnership firm is not required to maintain its books of accounts or get its accounts audited or even file them with any authority. So, but that would not be so, in case of an LLP or a company. So that is one point of distinction, which on the entrepreneur should keep in mind, that, there will be more flexibility when it comes to probably a partnership than a little lesser with an LLP and maybe the least in a company. So that is one important point to be kept in mind. Another point is that of liability, that, whether you as an entrepreneur would be personally liable for the liabilities of your business. So that is an important point, and there is a distinction. So in case of a partnership, that liabilities, the entrepreneur would be personally liable for the liabilities of a partnership, and that may not necessarily be so in case of a company or a LLP. Third, and I believe the most important point would be taxation. That is, in case of a company, there would be a two-tier or a double-tier taxation. And while in case of an LLP or a partnership, there is only a single tier. So I'll discuss that in detail. This was just to give you a brief background as to, what are the three important factors. So the entire discussion will now revolve around these 3 points. That is flexibility, liability of the entrepreneur with respect to the business, and taxation. So first of all, just to give you a brief idea, a partnership is not a separate legal entity. Under the terms of the Partnership Act, it is defined as a relation between persons who have agreed to share the profits of a business carried on by all of them. And basically, a partnership arises out of a contract. So it is not as if it is a separate legal entity. However, with respect to an LLP or a company, they will be considered to be separate legal entities. And the consequence of that would be that, that entity like the LLP or the company would be able to hold assets in its own name. It is capable of suing or being sued in its own name. Another point is that of perpetual succession. So just because in case of a partnership, it is possible that because the partners changed, the partnership dissolved. However, that is not the case in a company or LLP. In such a case, like with respect to LLP and a company, there is a case of perpetual succession. So from that perspective, also, from the perspective of running a business and having it continue, LLP or a private company might be a better vehicle. Now coming to just a small point of registered office, that, like I said, that, more compliances with respect to LLP or company. So a partnership is not necessarily required to hold a registered office, while that would not be so with respect to LLP or a company. Few other points I would just like to discuss here. One is that of, foreign investments or loans. So if you are looking to get a foreign investor purely as an investor and not as management, that may not be possible in a partnership unless you make that person a partner in your partnership firm, because there is, no concept of a separate entity into which he can invest. In case of an LLP, this is possible to get FDI as well as a company. There are more restrictions with respect to FDI when it comes to an LLP, such as, there may be restrictions with respect to raising of ECBs, that is external commercial borrowings. That is a good enough vehicle for companies to raise funds. Another point is that FIIs, that is foreign institutional investors, may not be permitted to invest in an LLP. So these are a few points with respect to, with respect to the fundraising aspect, that these were the points of distinction. Then, as I said, with respect to taxation, in case of a partnership and a LLP, there is a single layer of taxation, which means that once the profits are taxed at the entity level, and thereafter they are passed on to the partners or the owners. At that stage, that is at the time of distribution of profits, there would not be any tax in the hands of the partners. Now this is true only for a partnership or LLP. In case of a company, you have a double tier taxation, which is that once the profits are taxed in the hands of the company and they are distributed to the owners in the form of a dividend, then that dividend shall also be taxed in the hands of the partners. So just to give an example, suppose 100 rupees is a profit earned by a partnership and a LLP and a company. Now 30, assuming that the tax rate is 30%, 30%, 30 rupees you pay as tax. Now 70 rupees remains. Now once this 70 rupees is passed on by the partnership or the LLP to the owners, there is not going to be any further tax. But when this 70 rupees is passed on by its company in the form of dividend to its shareholders, they are going to pay another 30% tax on it. So even from a taxation perspective, this is something that should be kept in mind, that from a liquidity perspective or cash outgo perspective, taxes are going to be higher. And another small point I would like to put forth is that of ESOPs, that in case of a partnership or LLP, if you want to give someone capital, it can only be by making them a partner. But in case of a company and basically startups, as is seen practically, they are usually looking to issue ESOPs to their employees. Point being that they may want to hold on or attract talent based on the fact that subsequently there is going to be an increase in the equity or their valuation of their shares. But so this, from an ESOP perspective also, a company would be a preferable vehicle. So whether you are looking to give ESOPs, whether what is your perspective with respect to taxation, what is your perspective with respect to fundraising from foreign sources, all those are important points. Now I'll just quickly deal with even with respect to capital. Now when you put in capital and withdrawing it is very easy in case of a partnership or a LLP. But when it comes to a company, that will have to be done in the form of a buyback of shares or a capital reduction. Now, a buyback of shares has its own set of compliances to be made. That only 25% can be made. You need to be a profit-making company. All those issues are there. Or with respect to capital reduction, you will have to approach the courts, that is the NCLT, for the purpose of capital reduction. So there again, it's not as simple as you put in the money and just withdraw it. To withdraw the money, again, it is a long-term process. So with respect to flexibility, we have like easier flexibility with respect to capital withdrawal when it comes to LLP or partnership as against a company. Even with respect to earning interest on the capital that you put in, it is possible to earn interest on that capital when you are a partner in a LLP or partnership. But when it comes to a company, again, no interest on the shares that you hold or the share capital that you have infused. So last point that I would like to talk about, and an important one, is that of liability. So that is again a very important consideration for the should be an important consideration for the entrepreneur when he decides to choose the entity to run his business. Now, when we talk of liability, in case of a partnership, the partner is jointly and severally liable with other partners for the is responsible with other partners for the liabilities of the partnership. And that is not the case in case of an LLP or a company. So to give an example, suppose there's a partnership, LLP and company, all of them owe 50 lakh rupees to their creditors. Now this 50 lakh rupees, the creditor is looking to recover. It approaches these three entities, that is partnership, company, LLP, and they are unable to pay. Now in case of a partnership, the creditor can choose to proceed against the partners and recover the money from them in their capacity as the partner of that partnership. And another important point is this liability is joint and several. So suppose, for example, you have two partners, A and B, and the partnership is unable to pay, creditors come after A and B, and A says that I am unable to repay the dues. Then the creditors have the right to proceed only against B and recover from him. So that is one very important distinguishing factor between partnerships as against LLP and companies, because in case of a company, even if 50 lakhs is owed and not paid, then the creditor does not have the right to proceed against the LLP partners or the shareholders of the company. That to that extent, that right to recover the dues or the liabilities are limited only to that entity. Here I'll just mention one small point, that in case of a LLP, the only distinction or an exception that is made is that in case there is a fraud committed by the LLP and the partner is also involved, then in that case the liability of the partner becomes unlimited. So this is the only one exception where, in case of a fraud, that liability becomes unlimited. Otherwise, the liability is limited when it comes to company and a LLP. And just to quickly tell you about the regulatory requirements, maintenance of books of account and filing of annual returns, again, it is not necessary for a partnership but would be necessary or mandatory for a LLP or a company. Getting your accounts audited, now again, this is from a statutory perspective, that for a partnership it is not mandatory. Then for an LLP it is mandatory only if your capital contribution in the LLP is less than 25 lakhs, it's more than 25 lakhs, and the turnover is 40 lakhs. While in case of a company, it is mandatory in all cases. And even with respect to meetings, in case of a partnership or LLP, not compulsory, but in a company it is. So, with respect to compliances, it can be seen that a company has many more compliances. And just a short point, that recently in August 2021, the Parliament has made certain amendments to the LLP Act. And now they have also introduced a concept of a startup LLP, and they're yet to notify the rules for the same. So from that perspective as well, it will be important to keep note or keep be abreast with the latest developments, because even the government is looking to promote startups, and which is why they have come up with this concept of a startup LLP. Like Siddharth mentioned, even within a company, you have the option of a one-person company. So from that perspective, considering, like, you have to keep different factors into account, and which is why probably, like, answering the first question, that is why these different factors are what the lawyer will guide you through, and probably a discussion is required to be had with an legal advisor, to decide what will be the right choice. With that, Siddharth, I think another point is that, when you, like, at the very initial stage, other than the fact that you have to choose the entity, when there are more than two founders, it is also important to have an agreement between the founders. So can you please shed some light on that as well?
Yeah, sure. Thanks for your explanation and insights, Kunal. So, like I'm going to assume that it's a private limited company that you're incorporating. As you rightly said, though you can choose various kinds of vehicles, usually if you're looking to scale up and you're looking to get investors on board in the future sometime, most people eventually choose a private limited company. And in a private limited company, let's, like you said, say there are a couple of founders. They are what they should be thinking about is the fact that their relationship as founders, right now it's based on trust. Right now, both are putting in a lot of effort. That relationship is going to evolve. And the idea is, how do you promote harmony in the business? How do you provide a foundation for exponential growth? And as you grow, as founders grow, they realize that securing their individual interests is important, and a sense of fairness and security. The impact that has in preventing misunderstandings and building trust is very significant. So you have to plan for unanticipated circumstances. You have to lay out a fair exit strategy, and by doing that early on, you are able to save time, energy, and money in the future. Like you correctly said, it is a contract. So while the articles of association of the company will reflect how the company will take decisions and how the company will rather function, the shareholders agreement will determine the rights and duties of the founders intersay each other, one another, and also vis-a-vis the company. And eventually those will get reflected in the AOA as well. So at the initial stage, I think founders, one of the questions that they may have is, how do I discuss these things with my friends and family? Am I being selfish? Am I by thinking in this particular way, or should I be prioritizing my time and money early on? So at the outset, I can say that yes, they should be prioritizing this, right? So to move ahead, also one more point here, that if you thought through your founders agreement early on, Later, when angel investors and institutional investors are coming to you, they are likely to be more impressed because it will show seriousness of the team. See, when capital is invested, it's invested not just because of the idea or the patent, but also because the founders are being backed. So the seriousness of the founders and how they are operating will be reflected if they a little better, let me say, they have a founders agreement in place. So what would be those key points, right, that they should consider early on? One point, of course, is what percentage should I have of shareholding should I have in this entity? So there is no hard and fast rule, of course. It's not necessary that founders have to be equal shareholders in order to participate in the business, or in order to even retain control or take decisions. There is no, it's not necessary that just because a founder is bringing capital in the start, that he or she must have a larger shareholding, right? Sometimes time, resources, and other resources and effort is valued far higher. You also see in cap tables promoters having only 5% and 6%. If there are, say, 3 or 4 promoters, sometimes promoters have only 5 or 6% shareholding as well. But usually there is I see an equal distribution. So one is founders should have clarity on what they're bringing to the table and what their shareholding percentages will be. Second is they should commit upfront that they will transfer all the intellectual property into the entity, because it's important that the entity should own intellectual property and not an individual founder, because later it could become a problem, right, for the other founders. If one of the founders holds a trademark or holds patent rights or holds license, owns the software or makes a claim on the company. So to avoid that, it is a good idea to have either an intellectual property assignment deed signed early on, so that even if there has been some pre-incorporation work that parties have undertaken, all of that is very clearly in the control and ownership of the company. And the third thing founders would think about is right to a seat on the board. Like I said, let's say there are 3 founders and each holds 25% or a little more than 25%. Maybe the 4th person is a bunch of family and friends, who are part of the cap table. The point is, it's okay to say that 2 founders will override a 3rd founder from time to time. You can agree on that kind of an arrangement, but there would be some things that the founders would not want to lose control over. So one of those things is having the right to at least a seat on the board. And that 50%, if you have more than 50% shareholding in a company, you can appoint and remove directors. So as a promoter, you don't want to be removed by your other 2 friends in an adverse situation either. So having that right incorporated into the Articles of Association is very important. Likewise, certain decisions you would not want the other founders to take without your consent. And that is where the idea of entrenchment comes, which is, even if the Companies Act says with 50% shareholding, you can go ahead and take a decision. An entrenched term will make sure that consent has to be sought from you as a minority shareholder in that relative context. As a minority shareholder, that you permission has to be taken from you before decision making. So these could be some of the things that early on you incorporate into your Articles of Association and shareholder agreement. Clearly, the time that a founder spends in the company is important. So that is, the founders don't want the other founder to be doing side business. They don't want him or her to sell shares to a competitor or say sell shares to somebody else. So having a lock-in on those shares is important. Having on the transferability of shares, having a vesting provision is important, so that each of the founders earns their shareholding, even between and amongst themselves. Usually you see these terms, of course, with when investors are on board. But I would say even with founders, having some of these restrictions and some of this understanding on how I will earn my equity could be relevant. Prohibiting, like I said, transfers to competitors. I guess I also mentioned the scenario where certain items should be entrenched. So that I have covered. I guess the other point is of non-compete and non-solicit, which also I mentioned that founders should not be free to do a side business. Whatever they do should accumulate into the company. And tomorrow, let's say a founder does want to exit, he or she should not solicit employees, customers from the business. So I think founders would feel satisfied if they have some of these guardrails early on. And yes, you have to cater for situations where there is death or disability, right? It's unlikely to happen, but hopefully, but let's say it does. You don't want, even if the equity was to pass on to a family member of that person, a relative, what would happen to that equity? So you don't want dead equity. So even with and between amongst founders, there should be a provision where founders can purchase equity from each other at either fair market value, right, or at par value, depending on the situation and circumstance. So there have been cases where founders have engaged in fraud, or they may have not followed through on the shareholders document. So there should be a penalty there for them, and that penalty could be in the form of a sale of shares to other promoters at lower than the fair market value. So something of that kind early on can be worked out. More importantly, in order for your shareholders document to look good when it goes to a angel investor or a VC, good corporate governance provisions can be incorporated early on. So these are things that you can think about. Ethics, accounting practices, information rights and transparency, any other principles, how you treat your friends and family early on is also going to reflect in how you treat third-party investors who you don't know. So that is there. And of course, a good dispute resolution clause. Either you go in for arbitration, or you may have a few terms that insist on mediation before arbitration, because what you don't want to get into is litigation. That's for sure in India, right? You want to avoid that. So the more clarity you have early on in your founder's arrangement, the better. So yeah, that's a little insight into why you should have a founder's agreement in place.
So Siddharth, having discussed, at the initial stage, what are the factors to be kept in mind? Now, suppose this is taken care of, I've chosen one entity, either partnership LLP or company, and now, I also have a founder's agreement in place. And now once the company is set up, with respect to, we've been seeing that the Indian government is also promoting startups. They have the Startup India program. So, can you just share some light on that as well?
Yeah, sure. So there is the Ministry
of first, maybe, what you could take us through the eligibility first.
Yeah, sure. Yeah, so basically, this is a policy from the Ministry of Commerce and Industry. There's a Department for Promotion of Industry and Internal Trade, DPIIT, which regulates this policy, and they bring out notifications clarifying what a startup, what kind of a entity would be eligible to be called a startup. So right now, either you're a partnership firm, or you're an LLP, or you're a company. These three body corporates, if I may call them an association of persons, would essentially be allowed to register as a startup. Now, there's a time period that they've given, which is 10 years, for which, if you are recognized, you will have this benefit of being called a startup officially. There is also a turnover cap. So if you exceed, say, a turnover of 100 crore in any financial year after you've incorporated, then you will lose this eligibility. You lose the registration. So you should not be earning, more than 100 crores. The turnover should not be more than 100 crores. And obviously, they're looking for innovation. They're looking for some kind of development or improvement of products, processes, services. They're looking for whether you have a scalable business model. with a higher potential of employment generation or wealth creation. Kunal, earlier today, we happened to just speak about this point, which is that some entrepreneurs may be worried as to whether they will meet this criteria. And I can tell you from experience that they need not be, because it's really easy to get this. Let me say it's relatively easy to get this registration if you're genuinely meeting the criteria. And it's not like you need to have, only innovation or necessary improvement in a product. Even if you have employment generation potential, the evaluators will value that. And I have seen many startups. In fact, I have not come across a startup yet that has been denied registration. I'm not saying that it doesn't happen. I'm sure it happens, and I'm sure people are denied registration, but I haven't come across it. So to answer your point earlier today, Kunal, your question, no, people should not be worried when they're applying. I guess I should also explain how you can apply. It's very simple.
Yeah, just take us through the registration process.
Yeah. See, you go online to Startup India, the startupindia.gov website. It's either via mobile app or through the website, you can make your application. They are not going to ask you for too many details, a certificate of incorporation, maybe a write-up on how you're working towards innovation or scalability. They will want to know what stage of business you're in. Are you at a stage where you're still ideating, or are you at the validation stage where you have a minimum viable product, or have you gained early traction? So do you have a bunch of customers already, or are you kind of scaling up now and you have sustainable or stable profits? So they just want to know, right, where you are at. They may ask you for a pitch deck. They will ask you for a website link or a video, basic other details of directors, PAN number, right? If you have a patent, they'll allow you to give details about that, trademark, etc. So earlier they used to have a little more difficult. They had a few additional steps which are not there anymore. So they required you to get a certification from an incubator earlier. Now that is not there. Earlier you had to have an MSME certification. Now it is not there. So the steps, I believe, at least in my humble opinion, are relatively easy. But so you don't need a professional, really, frankly speaking. And as I recall, there was a time when the government even brought out a guideline saying that professionals will not charge for this activity. So that was also made quite clear at one point in time. So just to let everybody know, they can go ahead and do it on their own. There are a few caveats here, which is if you are, a company that has come from, say, a merger or a demerger or an acquisition or an amalgamation, you are not going to get this registration, right? Unless the amalgamation or the merger has happened between two startups, or it has happened between a startup and a small company, as per the definition of small companies under the Companies Act. So unless that is the situation, you are otherwise not going to be able to register. Likewise, they've recently brought out guidelines which state that if you are entering into a joint venture, you will not be able to take startup recognition, or you may even be derecognized. That is a little surprising to me, because while I understand what they're trying to do, they don't want people to free ride, right? In a joint venture, but the fact is that the joint ventures can be very useful to startups. So say a small startup does a joint venture with a larger, like a defense startup does it with a much larger company. The benefit that the defense startup would get from such a contractual project-based joint venture would be substantial. And so I would hope that the government will clarify that what they mean is joint ventures where some kind of equity and investment or special purpose vehicle is involved, and not joint ventures which are contractual in nature, where there is a kind of partnership over a project. So if it would be good if they make this clarification. Likewise, if you're a holding company or a subsidiary, you will not be allowed to register. So there are some of these restrictions. Again, If you're incorporated outside India, you will not be able to get this recognition. And now what they've introduced, another guideline is that if you hold less than 51% shares as promoters in the startup, then again, you may not get this recognition. I find that to be a little bit of a problem, because the fact is that private companies, while there is a distinction between equity shares and preference shares, and even equity shares, if you want to, usually under the Companies Act, have differential voting rights. There is a procedure that is set out therein. But for private limited companies, it is exempted specifically. So it is very much possible for promoters to hold 25% or 30% and still control the company. There's, even the nature and the class of equity shares you can play around with a lot more if you're a private company. And if you're a startup and a private company, you should be able to achieve this with less than 51%. So shareholding, right? And see, over the course of 10 years, you do find very often shareholding coming down to 30 and 40% as well. It is always preferred that it is higher, but sometimes you do have this situation. So given that the period is 10 years and startups mature, right, even after being registered, and they grow and they have multiple rounds of investment, this 51% that promoters must have seems to be a little bit of a hassle, let me put it that way. Again, related party transactions are allowed only if they are you do it on an arm's length basis. So these are some of the conditions that are around startup registration.
So Siddharth, having dealt with the startups which are eligible to apply and the registrations, now what are the benefits that a startup can get under this program once it's been registered with the DPIIT?
Yeah. So one clear benefit is some of your patents or trademarks or design registrations that you may want to do. You can apply to get that done through a facilitator who's empaneled by Startup India. And while government fees are going to be payable, other fees are not payable. Those are waived off eventually. So you can benefit in that way. The other way you can benefit is your patent applications will be fast-tracked for examination. So you will realize value of your product much sooner, because once you get the patent, you can take it to market and run with it. So that is another benefit. A third benefit is that self-certification under employment and labor laws. So startups can self-certify, and there are about 6 labor laws and 3 environmental laws. One of these labor laws are Interstate Migrant Workmen Act, Payment of Gratuity Act, Contract Labor Regulation and Abolition Act, the Employment Provident Funds and Miscellaneous Provisions Act, and the Employee State Insurance Act. So what the government is saying is that, and they provided formats, state governments as well as the center, where you can mostly, you will go onto a portal called Shram Suvidha, and you will apply for self-certification in those formats. And then you have this, I would call it a luxury, that the inspectors will not issue notices and come to your office to check as to whether you are following the rules and regulations. They will make that assumption based on the self-certification. You still have to, of course, comply with the acts, but you won't be troubled, presumably. Though, it's interesting that the government says, in some cases, we may still do random checks. I would really hope that they don't catch you, because it can be really difficult, to deal with inspectors, and especially the labor department. So I guess one thing I want to just say here is that the labor laws that I have mentioned, if they sound alien to you, believe me, they're not alien. They will apply to you even if you're a startup. For example, recently, when I had asked a startup to let me know if they're following the Industrial Disputes Act, I got a clear answer saying, look, what industrial, I'm not an industrial establishment. So, how are you even making this suggestion? But the fact is that if you are, say, employed in if you're not employed in a managerial capacity, if employees are not employed in, say, an administrative capacity, they're not discharging supervisory functions, but they are in fact undertaking technical functions, maybe unskilled manual functions, clerical activities, they could potentially be covered under the definition of a workman, right? And through that, certain obligations could come upon the company, including having a grievance redressal committee as per the provisions of the Industrial Disputes Act. So how you terminate an employee then would also, what kind of natural, what kind of rights you give to the employee before terminating him or her would come into play. So these labor laws and this benefit is not insignificant. Let me put it that way. That's one benefit.
Right.
There is a.
So with respect to government procurement, also we understand there are certain benefits. Right?
Yes. See, government procurement point is that usually they ask you to give these earnest money deposits. They expect you to have certain number of years of experience or a certain turnover. This becomes difficult for a startup. So it may have something really innovative, but they don't have that kind of background or those number of years to prove and meet the eligibility criteria. So the government has said that from time to time, on a case-to-case basis, it will ease that criteria whenever it issues RFPs. So the tenders that it issues will ease this criteria for startups. Also, they have a portal which allows for where you can directly seek to service the government, and the government will give you importance because you're a startup. So that benefit is there in terms of the procurement policy. Yes. I guess there are still a few more benefits that I could cover. One is, for example, if you're a startup, you can issue a convertible note. So that's a big deal in a sense, because very often you don't know how to value your company, right? You're still very small and you want to be able to issue an instrument without having to value the company. So this convertible note option is one type of an instrument that you can use. It's mostly a debt instrument, but it's a debt that gets converted into equity as per the terms of the instrument, which terms you can determine with the investor. So this flexibility is afforded only to startups, provided you have, for example, 25 lakhs minimum investment from an investor. You are able to avail of this instrument. And see, things from the government side aren't always clear. Many startups, what they do is they undertake the normal, usual private placement procedure, but they don't issue a valuation report, because the whole objective is to convert it at a future date when the valuation becomes more clear for the startup. So this is one benefit I can talk about. The other benefit is with respect to ESOPs. There is a restriction in the ESOP policy that you cannot, promoters cannot benefit from the ESOP scheme. Likewise, directors who have more than 10% shareholding in the equity shareholding of a company, they cannot benefit from the ESOP scheme. But if you're a startup, your ESOP scheme can allow for promoters and directors with this 10% shareholding to also receive ESOPs. And why that's important is because as the startup grows, there comes a time where, like I told you, the promoter's shareholding reduces substantially, and you need to have skin in the game. In fact, new investors, new rounds of investment, when they're coming in, the investors want the promoters to have more shareholding. So they would again tie it into the number of years that the promoter is going to continue in the business. And so that benefit of receiving ESOP is given to promoters and such directors for startups. There is also a very technical benefit in the sweat equity rules, where while otherwise sweat equity is something that is limited to 25% of paid up capital, with a startup, it can issue sweat equity up to 50% of its paid up capital. That's a very technical point, but it's still relevant. I guess I guess broadly, I have covered some of the important ones. There's also a fast track. There's also a fast track winding up procedure under the insolvency code. So startups with simple debt structures or those that are meeting, the criteria therein, they can be wound up within a period of 90 days from the date of making an application. It's easier said than done, but at least the provision is there.
So I think these were all like, the benefits from a legal perspective. I'll also quickly deal with what are the taxation benefits that you would get once you register as a startup under the Startup India scheme. So first, I'll just quickly deal with the aspect of angel tax. Now, to just give a brief background, what is angel taxation? So you have the section 56(2)(7)(b) in the Income Tax Act, which provides that, where shares are issued at a share premium which is much above the share market value, the fair market value, then the difference between the premium amount and the actual fair market value of the shares will be treated as the income of the company which is receiving those shares, that is the company issuing the shares. Now the purpose behind having this provision in the act was originally to ensure that promoters don't convert their black money into white by using this route. So you had many instances where shares were being issued at a much higher price, or equity was being pumped in at a price which was much higher than the actual fair market value of the companies. So it was to plug this gap, of converting black money into white, that this provision was brought in. But an unintended consequence of that same was that even startups would fall under this provision. Reason being that initially the startup usually would just has an idea. It does not have sufficient number of assets. Even if from a DCF perspective, like the discounted cash flow perspective method, even if you were to do a valuation, even then the value may not be very high. But you may have investors who see value in your idea or value in the proposition that you have, and based on that, they are willing to pay a premium which is much higher than even the fair market value. So this is what happens usually in the market, or practically. But a consequence of that was that this section, angel tax provision, that is section 56(2)(7)(b), would also hit startups. So you had tax officers issuing notices to startups, asking them to justify as to why the shares have been issued at a premium which is much above their fair market value. And this was causing a lot of issues. And even going ahead, in case you are a startup founder issuing shares at a much higher value. So from that perspective, to provide an exemption from this angel tax provision, the income tax department and the DPIIT, they have also given a registration process. So there's this form 2 which is required to be filed with the authorities. What is required? The requirements are that, first of all, the startup, as Siddharth mentioned, that you have a registration process under DPIIT. So that registration is the key to even claim angel tax exemption. Another important point is that the aggregate share capital and share premium should not exceed 25 crores. And this while computing this amount of 25 crores, you will exclude the share capital and premium which is received from non-residents, and as well as companies who are listed on the stock market and who have a net worth of 100 crores and turnover of 250 crores. That is, big companies whose shares are frequently traded. And you will also exclude venture capital funds. Basically, VCs will also be excluded. So when you compute this amount of whether your issued and paid up share capital is more than along with the share premium is more than 25 crores or no, you will exclude the amounts that are received from VCs, share non-residents, and listed companies. Another important point is that this investment, basically there are certain limitations on where can you invest. So there are basically, you cannot invest in jewelry, you cannot invest in shares of another company. There are limitations on investing in a residential house or a motor vehicle, a yacht. Basically, the whole idea is that you should not invest in assets which are not important or which are not central to the functioning of your startup business. So basically, as long as a startup is fulfilling these basic criteria, that is, it is registered with the DPIIT and recognized as a startup by them. The share value does not exceed 25 crores, subject to the exceptions that I gave, and it has basically not made any investment in the various assets which are specifically prescribed, and also undertakes not to make an investment for the next 7 years. So the basic idea being that, don't invest in other assets, focus on the business. So, and what has been done is that, like in case of DPIIT, you would have to make a registration and you would need a certification. However, here it is more in the form of a self-certification. So as Siddharth mentioned that, with labor law compliances, there is self-certification. In the same way, from an angel tax perspective, you have a self-certification which is brought in. So this has made it very easy for companies to ensure that, they are not hit by angel tax provision. Of course, there may be instances where, that share capital along with share premium may exceed 25 crores, or a company may have invested in shares of another company, and just for getting this exemption does not want to basically let go or dispose of those shares. So in such a case, what would have to be done, we will be discussing in our next session, where we will be discussing about investments. So but for now, this is the scenario when it comes to getting this is the process to get a registration or exemption under the angel tax provision. And quickly, I'll also deal with, so this was, with respect to the investment that you get, what is the exemption. I'll also quickly discuss as to what is the benefit with respect to the income earned by the startup. So there is the section 80 IAC. It provides that a startup is eligible to claim deduction of income or its profits for a period of 3 consecutive years. And this period of 3 consecutive years should fall within the first 10 years of its incorporation. And some of the very basic things to be kept in mind to be eligible to claim this exemption under section 80 IAC are that the startup should have been incorporated after 1st April 2016, but before 1st April 2022. So basically, what happens is that they, based on the budget, they give a cutoff period at the end of the year, but it has been seen that they have been extending this period. So even going ahead, if someone does want to register, probably he would be eligible to claim benefits under 80 IAC and not be ineligible just because he doesn't fall within this period. It is expected that this period would be continued year on year. Another point is that the turnover. So here there is one distinction here, that here for claiming 80 IAC, getting that 80 IAC registration, you don't need a DPIIT registration, because here the point is that even if you may have hit 100 crore turnover, but you are not eligible to claim that income tax benefit only for the year in which you have hit if you have hit 100 crore turnover in that particular financial year. So basically, as long as you don't hit for that particular year, if you don't hit 100 crore, then you are eligible to claim this income tax exemption. And to quickly summarize, another important point is that it should not be formed through any reconstruction. So basically, it should not be the case that you have an existing business. Now you see that government is providing exemption to income of startups. So, whatever is my current business, I'll transfer it to a startup and I'll get this exemption. So that is not allowed. Basically, the whole purpose behind this exemption is to ensure that, people put in that investment and come up with a new idea, and only those startups are eligible. And even with respect to plant machinery, they've said that you should invest in new plant machinery, not use the plant and machinery of some old basically FN earlier which is already being used. So that is the idea, that you should be a startup which has a new idea, which is you're investing in new assets, and you should be a new business. And based on that, you will have to basically make an application to an interministerial board, and this interministerial board will take up the application. And I've went through the minutes of meetings for few of these interministerial board meetings, and basically what is seen is that as long as it's a scalable idea, if it is an improvement of sorts, or if it is leading to health employment generation or wealth generation, or it is going to help a particular sector, then in those cases it is seen that permission has been granted, or that registration under 80 IAC has been granted. And most cases where it has not been granted is where it is a form of reconstruction. So they specifically mentioned that, this was already an idea which was held in another company, and just to claim this exemption, they have, moved the particular product or patent to a startup. So that seems to be the critical point, that, just because it may not fall under innovation doesn't mean that you won't be allowed to get apply for exemption. As long as it leads to scalability or employment generation, that should also be good enough. Though practically it is seen that there are quite a few, like maybe a few startups in lakhs which are registered with the DPIIT. However, very few startups, like a few thousand only, have been granted registration under ATIAC. So that is one point that should be kept in mind, that even the government is trying to promote startups by giving them certain exemption. And the importance is that okay, under ATIC you may get tax exemption only for 3 years, but there are two more benefits which have been given by the government. One is that with respect to reinvestment. So basically what happens is that when a startup founder, for example, sells his residential home, on the gains that he receives, he will be required to pay tax. But what the government has come up with an exception, where if these gains, the consideration that is received from sale of house, if it is invested in the shares of a startup, and as long as the startup uses these capital proceeds to invest in new plant machinery, then in that case, the capital gains will not be taxed in the hands of the founder or the promoter. So basically, the idea is that, this provision would help a entrepreneur to have a greater investment in his own company, or with respect to raising of funds, even if a residential house is sold, that money can then be invested in the shares of the startup. So from that perspective, this is helpful. And lastly, I'll just give a very small point, that this is actually a very important provision with respect to losses of a startup. So under the Income Tax Act, you have a provision, section 79, which provides that if a startup has certain losses, and now once there is basically what happens is that these losses can be set off against the income of another year. So when these losses, basically if there's a change in shareholding by more than 50%, then these losses cannot be set off by the startup. So what is seen is that usually in the first few years, a startup would have losses, and maybe by the 6th or 7th year, it would start making profits. So these losses could have been set off against the profits of subsequent years if there was no change in shareholding by more than 50%. But considering the practicalities of a startup, you have venture capital funds, investors all coming in, and so there will be major changes in the shareholding of startups, and accordingly they would be hit by this provision where they would not be allowed to set off losses. So provided that you have a registration under ATIC, even this provision will not hit a startup as long as the shareholding is the same. So shareholders should be the same. The shareholding may have changed, but as long as the shareholders in the company, so even if the shareholding has gone down from 50% to 1%, but as long as that person continues to be a shareholder, that startup will be allowed to set off its losses in subsequent years. So this was just a brief background about how tax benefits have also been granted by the government, and this is something which a startup entrepreneur should keep in mind when, like, once the initial stage of setting up a company and everything is done. This would also be a major benefit of applying under the Startup India program. So with that, I think, Siddharth, since we've covered the benefits of Startup India program and initial phases, are there any compliances or documentation that a startup entrepreneur should have in mind once the business has started? And you practically, have you seen any cases where entrepreneurs are not focusing on a few points when conducting the business?
Yeah. No, I think those, see, one is, of course, your secretarial compliances, which to a large extent, your company secretary or CA should take care of. And even labor compliances are there. I briefly talk about them. One, why they're important is because as you grow as a startup, there are times when investors won't touch the entity if it has too many there are too many offenses that have been committed. So I think you need to have a clean record, basically. If you don't, yes, it's possible for you to transfer assets into another company and then receive an investment, but it makes it that much more complicated. So keeping a clean record, clean house is important for a startup. I do see that many startups fail to do simple things like pay stamp duty on agreements, right? I think we know that if you don't pay stamp duty on agreements, then your agreements are not enforceable until you have paid a penalty at a future date. So you want to keep your agreements enforceable. Sometimes startups say that, oh, this is an e-agreement, right? So stamping is not required. Now that may vary from state to state. A state like Maharashtra is very clear that e-agreements would have to be stamped. So this is one issue that I find. Other is sometimes, startups agree to electronic forms of signatures. And when I say electronic form, I don't mean electronic signature. I mean cut, copy, pasting a signature like from a photograph, using snipping tool and attaching it to the document. Now, if you do that, it doesn't make your document, it doesn't make it unenforceable, right? But certainly there are some benefits, some presumptions in a court of law that come about when you do it in the manner that is authorized under the Information Technology Act, right? So when you do it in that manner, which means that the digital signature certificate is authorized, it has gone through a process that is validated by a certifying authority, which is certified by the government. When you use that mechanism, then you have a presumption in your favor that the other party, when it attached that DSC, intended to execute the document, and indeed that very person has executed the document. So the authenticity and validity of that signature is presumed. And that's very important. Tomorrow, when you're going to a court, you don't want to have to start from the basics of proving this point. So I think that I find. The other is I have startups which say that the Shops and Establishments Act won't apply to me because I have only one employee operating from a particular city. And they operate from a co-working space. So it doesn't matter if if the act says that usually the definition of establishments under various Shops and Establishments acts it's very wide. So it covers such a situation. Maharashtra, in fact, has a slightly better policy. If you have less than 10 employees, you just have to provide information to the competent authority. You don't have to actually follow through on many of the compliances of the Shops Act, but other states are not so lenient. So you have to be careful. You can't say that the Shops Act doesn't apply. I find board minutes and minutes of general meetings aren't maintained. Share certificates are not stamped. Statutory registers, register of members, register of renewed and duplicate share certificates, register of directors, register of share transfers. These things aren't always kept as they should be. And the point is that the Companies Act is quite particular about compliance and penalties. So even if I'm talking secretarial stuff, even if it is not specifically mentioned in that section of the Companies Act that this will be the penalty, there is a catch-all provision, and that catch-all provision is such that you are fined, say, 10,000 rupees, and then on top of that, for every day that you are contravening the provision, you are fined 1,000 rupees a day. So the provisions are very strict. Also, if you committed an offense, you can compound the offense. But the point is, just because you paid additional fees on filing, for example, doesn't mean you can go scot-free. You still have to go and get it compounded because the offense was committed, and that involves costs. So filing documents on time and maintaining these registers, etc., is very important, I think. I guess I've talked about labor law and how it applies. Whether it is, sometimes I find startups saying, look, we don't have any women employees. So, the Prevention of Sexual Harassment Act and the compliances therein won't apply to us. Or we need not notify, we need not have a maternity benefits policy. But that's not true. If you have a certain number of employees, say more than 10 employees, that 10 or more than 10 employees, then you have to have an internal complaints committee where and the policy has to be as per the act. So where a woman can go and, make a complaint. So I think some of the reasoning needs to be just recalibrated. Your HR policies must cover things like Rights of Persons with Disabilities Act. This is there are provisions against discrimination against a person with disability on the ground of disability. So you're supposed to have and notify an equal opportunity policy, right? And if private establishments have 20 or more employees, they're required then to maintain records, registers. So this happens across the board with labor laws. Even with the ESIC or EPF, if you're more than 20 employees, it becomes applicable. Contract Labor Act becomes applicable to you, even if you have contracted out housekeeping or security, and a certain number of those persons are working with in your establishment through the contractor. The act still applies. You are responsible for whether your contractor meets the liabilities that it is supposed to. So I guess this is one more aspect. The other thing I find is software companies who are exporting software. They are earning foreign exchange, but they decide not to file this Form Softex. Form Softex has to be filed with the STPI. So basically, that's another compliance where people say that they don't do it sometimes. This is not to say that startups are not complying. Many of them are. But just some of the examples, that I have found in practice of non-compliance.
Right. So from personal experience, I think another point is also, when you have startups which are operating using their websites, where the website is also a key component of their business. One thing that we've seen is that terms of use and especially privacy policy is not specifically given. Now, yes. I think they should keep in mind that a privacy policy is mandated as per the law, especially when you're collecting data. And even if you're collecting data where registration is required of that person, where he's giving his password to you, or you're collecting his certain personal information such as his email ID and storing it, then even from that privacy policy, then from that perspective, a privacy policy becomes important. Basically, the whole point of a privacy policy is to give an idea as to what data is being collected, how it is being collected, and whether once it is taken, then how are you using it, and whether you yourself are using it, or are you also sharing it with some third party. So these are the things which have to be mentioned in the privacy policy, and it is mandated as per the law, failing which there may be certain penal consequences. So this is something, and even terms and conditions may be not mandatory unless you have an intermediary where you have to give terms and conditions. But as a matter of practice, I think it would make much more sense to that a terms and conditions policy is also in place with respect to the use of the website. So where, for example, you have someone, you provide allow your users to comment or post something on the website, then in such a case it would always be better to have terms and conditions which specifically mention that no obscene material is to be put up on the website or on those lines. So basically, this is something we've seen, that even terms, conditions, and privacy policy are two important things which should always be kept in mind by a startup entrepreneur. And
if I can just add to what you said, which was that you talked about intermediary. The definition is broad. So even if you're providing a software software as a service, it is possible in some situations that and you have limited parties who are coming onto a portal or through an API who are essentially gaining access to the service. This may apply to you, and you will have to at least share a privacy policy with them and follow other aspects of the Information Technology Act. So absolutely. Also, one point of that grievance officer, often grievance officer needs to be specified in these documents.
So I mean, compliance with the IT rules is important, and that is something we should keep. And another point I thought was with respect to GST registration, that although if the turnover is probably less than 40 lakhs, then you don't need GST registration. But from a practical perspective, even if you are not paying GST, the person who's paid GST, I mean your supplier, may want to claim credit, input tax credit. So from that perspective, it may make sense to have a GST registration as well. So I think, these are a few of the important compliances that should be kept in mind. Siddharth, if you have any other compliances in mind?
I guess just in terms of housekeeping, it's important, not compliance, but it's important that startups should have their employment agreements in place. They should have they should be signing NDAs with vendors and customers and enforcing those. Very interesting one experience I had when I was in the initial years of practice. I had hardly 2 days to turn this around, and a client came and said that he found out that one of his customers was violating his intellectual property, and in a manner where tens of lakhs of rupees were being made, okay, on that intellectual property. So it's a startup and was losing money in this way, right? So we entered into a settlement agreement, but we were able to do that because the customer who was violating, and himself, was using and benefiting, had an investor where we were able to who we knew, right? So we were able to get them to the table and get them to sign a settlement agreement. But the fact is that the documentation was not really in our favor,
right?
And had we not had this leverage, where would we have been? So you have to be able to fall back on documentation and have that hard evidence in most situations. So yeah, that's why it's important to have, for example, an NDA or to enter into contracts with parties that you're dealing with.
So, and I thought I'll just mention here that, just as you have certain benefits with respect to startup registration, another point that, entrepreneurs may consider is also getting a registration under the MSME Act. So basically under this MSME Act, if you qualify as a small or medium or micro enterprise, then you will basically be allowed to get a registration with the, and that registration is called Udyog Aadhar. And basically you have to either be a manufacturing company or you have to be a service provider, and there are certain criteria with respect to the turnover and your assets. So basically once you fall under those, and which startups in their initial stages would definitely fall under, there are certain benefits. So one very important benefit is that the startup is entitled to claim interest on the dues which are due to it, which are outstanding towards it from its debtors. So basically the idea is that, under law, maybe you would be able to claim 8 to 9%, but under contract, but under the terms of the MSME Act, it provides that the interest payable is compoundable and the rate would be 3 times the bank lending rate provided by the RBI. So currently, if you assume that if you have to see, the bank lending rate is around 4%. So someone who has dues today from his debtor will be entitled to claim 12% compounded interest under the provisions of the MSME Act. And also it provides for a redressal mechanism in the form of a MSCFC, which is Micro and Small Enterprise Facilitation Council. And the idea is that through conciliation and arbitration, the recovery of dues would be made. So, instead of approaching, and another point is that considering that it's an MSME, the jurisdiction would lie where the startup is located. So where the registration office of the startup is located. So even if, you have someone whom you've provided services who is not within the state where your office is registered, maybe if you had to file a recovery suit and the cause of action and everything lay in the other state, then recovery suit would have to be filed in that other jurisdiction where the defendant is placed. But the MSME Act gives you the benefit of filing the case or like recovery suit in the jurisdiction where your registered office is. So that I think is a very important point. So that is something that can be considered. It's not a compliance, but it's an additional registration which may prove beneficial for some startups. So yeah, I think with that, we've covered today's topics, which was basically things to be kept in mind at the time of initiation of your business. Then what are the benefits of startup registration? And thirdly, what are the important documentation or other certain registrations which can be used by startup? Now I'll just take, there are 2 questions in the chat box, so I'll just take one. One is that if there is already a LLP and one wants to convert to private limited company, since in both cases the ROC is the same, would it be a conversion process? So basically conversion from LLP to ROC, would it be an easy process or cumbersome process, considering the fact that probably when you start off you may feel that an LLP is better for me, and over time you feel that no, I want foreign investment, or I would like to issue ESOPs. So you move to a private limited company. So can you just shed some light on that?
I mean, there is of course a procedure for doing it, and it does happen. You can convert LLPs to private limited companies. You have to follow through with the procedure as you submit the documentation that the ROC requires. They will ask you questions, usually 2-3 times, right? And you pay the amount that you have to. So there is, whether it's cumbersome or not, there is procedure, but you can get it done.
And okay, so thank you for that. And another one, there's a question from Saurabh Malhotra that at the inception, when the startup registers under these provisions, that is the Startup India program, and then after a few years it scales up and becomes a big company, then how does legal compliance transform? So, I mean, is there an increase in legal compliances once you are out of the startup regime?
Absolutely. The very next day, you have to start complying. So there is no option. So, for example, if you are an OPC and then you suddenly become your turnover increases massively, you become a private limited, you have to start, you become a private limited automatically, and then you have to comply. So likewise, you lose startup registration, any of the benefits that you had, you lose. So the very next day you will have to comply. So that's how it would work.
So yeah, I think that is also something startups would have to keep in mind, that this registration is or the benefits under the registration are only for a limited period of time. And so
yes, and you get used to it, right? You get used to complying. So you can plan for a scenario where you need to comply with a particular law or a particular, maintain a particular register or file a return. Those are things you can plan for.
So yeah, I think so we've covered, what we'd set out to do, and even covered the questions. So with that, I'll request Vaishali ma'am to kindly conclude the session.
Thank you, Kunal, and thank you, Advocate Siddharth. Thank you. First, it was our pleasure to have you for the study circle session. Thank you very much for accommodating this session in your busy schedule. Kunal had told me that you're very tied up, but still you did make time for this session, and it was very, very informative. Exactly what is required for startups who absolutely struggle with compliance and have no clue. And as you very rightly said, sometimes they're not even aware that they need to be compliant with several legislations. And there's always a mindset that this is not for me right now, unless and until I get into, say, full-fledged business. And somehow there's a mindset that a lot of concessions will be available because I'm a startup. So I think that was very important that you touched upon. And of course, you and Kunal together having this question answer mode also helped a lot in understanding. Otherwise, sometimes, a lot of legal jargon, again, startups tend to stay away from, and they are also hoping that they don't have to deal with lawyers, which unfortunately is not the case. So thanks again very much. We hope to have a continued association with you, and we'll trouble you as and when required. I mean, without asking, I'm already making this as a statement. I hope that's okay with you.
No, absolutely, ma'am. I mean, it's my privilege and honor to be here. Thank you for inviting me.
Thanks. And though we didn't have a presentation, neither have we recorded this session. But what we'll be doing is we'll be putting up a note of the things that we have discussed on the website, so people would still benefit from today's discussion. That's what we've been following, and I hope that's okay with you.
Sure.
Perhaps what we could do is Kunal could prepare a note, and we could share it with you. Once you approve it, we'll put it up so that the right message and the right contents go out, and we'll follow that as a rule. So thanks again. Thank you all the participants for being here and helping us also circulate the session's information widely. I know a lot of you have volunteered in sharing these flyers in your respective groups, and we are very happy with this association and very also grateful to all of you, because I know we get a lot of feedback, especially this information is for you, Advocate Siddharth, that we get a lot of feedback from younger lawyers saying that this is very useful. They take notes, and it's that's how they refer to the notes later on whenever things come up in their actual practice. So I know there's a value add to all these sessions. Though and this is for the participants, we keep struggling with the time slot. Sometimes, we've tried 11 o'clock, sometimes we've tried 4:30. We also try to accommodate the speaker's convenience, because we're trying to get the speakers from across India. So we of course give the preference to the speaker's time first. And second, we try to see where we can get maximum attendance. And we've not really reached a conclusion whether 11 is okay or 4:30 is okay. So I think we'll keep experimenting with this, so bear with us. And thank you so much once again. Thanks again, Kunal, for all this. I don't need to thank you really, because you are heading this initiative, but consistency is something that is sometimes very difficult to keep up with, that you do this every alternate Saturday, and I know so much effort goes into all this. So thanks again for this, and now over to you.
Thank you. So this was session 1 of our startup series, where the idea was to basically cover the registrations and basic documentation. In part 2 of our series, we'll be talking about investments, basically with respect to the equity matters of a startup. So we'll be dealing with ESOPs, issuance of advisory shares, and also with respect to investments, what are the different aspects of investment, how should an investment agreement be drafted. So those are the different points which we'll be covering in our next session, which is on the 11th of September. So with that, I hope to see all of you there again, and hope this session was useful for you. And I think with that, we'll conclude our session.
Thanks, Kunal. Thank you.
Thank you, Siddharth.
Thank you, ma'am.
I hope to meet you in person. So whenever you are in Pune,
certainly,
definitely catch up. Thank you.
Bye. So, thank you, ma'am. Thank you.